We're breaking news as we speak
Right.
about John Hackett's testimony. And it's probably, there's other interesting material received, but this is a witness, in my view, who's blown it wide open.
Right.
Am I exaggerating?
No.
So John Hackett, well, let's talk about who John Hackett is.
So Mr. Hackett is a former director of IPS. IPS is the Information of Program Services, I believe, of Programs and Services at the State Department, basically heading all of the FOIA, the entire FOIA program for the State Department. He came on board as the deputy director and then was elevated to director. He came on board in July of 2013. During the time that Cheryl Walter, who he also deposed, was at the time she was the director of IPS. In his testimony for the first, in July of 2013, he saw a photograph of Secretary Clinton holding a BlackBerry on the military plane that I think a lot of us has seen since then. So, and he saw it.
That's the one where she has the dark glasses?
Correct,
Yeah.
correct.
Yeah.
And after his testimony, looking up why it came out back during that time, I believe that's when she opened her Twitter account. And actually that was the photograph that she selected, I believe, for her Twitter account.
So Hillary Clinton liked
So-
that photo. Showing her using,
it was
using
posted
the
with
illegal
that,
BlackBerry.
But that was sort of the context of why it appeared, because I believe the photograph existed since 2011. I think it was because it was taken while she was at the State Department. So it predates 2013. He sees the photograph, and Mr. Hackett testified that raised concerns, red flags for him with respect, what is this BlackBerry? Is this a State Department issued BlackBerry? What does that mean for FOIA? Does that mean that there's an email associated with the BlackBerry? And how are we responding to FOIA requests relating to Secretary Clinton's emails? So he alerted...
Sounds like a troublemaker.
Right. He alerted his boss, the director at the time, Cheryl Walter, who then she elevated it to her boss, who was at the time Margaret Grayfeld. And his testimony is they did research, they assigned somebody to do an investigation as to what this email is about, but of significance is he recommended, and the director at the time, Cheryl Walter, agreed with him, and apparently there was a directive issued not to submit any more no records located responses to FOIA requests asking for Secretary Clinton's emails.
But they were a little late to the dance in that regard, because they already had known about her email system. And just take a step back, because part of this discovery meant us getting documents that we otherwise would not have been able to get under the Freedom of Information Act.
Correct.
And they gave us documents showing that they knew and lied about her email usage prior to Hackett looking at that photo and saying, oh my gosh, what's going on here?
Well, we know actually from another testimony in this case, one of the attorneys, Gene Smolansky, his testimony that they were aware of Secretary Clinton's email relating to Benghazi as early as in 2012.
And weren't they consulting the White House about it?
Well, at that point, his testimony is that they were consulting the Department of Justice.
And when did they start consulting the Obama White House about it?
So the Obama White House, as to information that we discovered in this case,
right.
Became involved in December of 2012, also in 2012, in regards to a FOIA request. Are you talking about the CREW request?
Yes.
A FOIA request from CREW, Citizens
CREW.
for Responsibility and Ethics in Washington.
A left-wing group founded, modeled based on Judicial Watch, of all things.
Right, and they had submitted a request for all records showing the number of email accounts that she used and her email address.
So they had a request that was, boom, right on target. They had, I think, asked across multiple agencies for alias requests of senior officials.
Right.
And with the Hillary Clinton request, oh my gosh, they asked about documents that would have revealed her email system.
Right.
And so they consulted with the Obama White House,
They did.
the White House counsel.
White House counsel's office.
And what was the response they gave to Crew?
They gave a no records response in May of 2013.
Okay, so I'm going to put a headline on this.
Okay.
The Obama White House coordinated the lies and obstruction of information about the Clinton email usage in October 2012 and early 2013. I mean, that's the evidence, isn't it?
In October of 2012?
December of 12, late 2012,
Late 2012.
early 2013.
Okay.
And then this other witness, John Hackett, comes in and he says, so that after all those lies had occurred, he blows the whistle. And he tells the boss who had previously lied, it looks like, to Crew, well, you know, she's using the system, she's obviously using a BlackBerry.
Right.
And they said, well, we're going to have to stop lying. I mean, I'm putting an editorial spin on it, but that's what this evidence suggests, that because of this one person, the State Department went silent. They didn't start telling the truth, but they went silent about her emails.
Right. They never, as far as we know, they never issued a correction to Crew.
So then the email issue becomes more public, at least within the State Department. And what is he's seeing all sorts of improprieties.
Right. So you have July 2013. This becomes an issue. So and then you have fast forward to August of. So it's kind of this time frame, July, August 2013, when they're trying to figure out, has the State Department ever issued Secretary Clinton a BlackBerry? And I believe Mr. Hackett testified that they made the inquiry and were told that she never issued that she was never issued a BlackBerry, a State Department BlackBerry.
So it was a personal BlackBerry.
So it was a personal BlackBerry, but nonetheless, that begs the question: she's using this on a military plane while she's Secretary of State. What's the email associated with a BlackBerry?
Right.
Then Mr. Hackett also testified again towards the end of 2013 and leading into 2014. There's another FOIA request where that, as a result of the search that was conducted, the State Department had located some records with her email address, the HDR22 at clintonemail.com. So we know that by the time, specific to this FOIA request and this litigation, we know that even before we filed this lawsuit, State Department officials were aware of Secretary Clinton's email use. Oh, and even Cheryl Walter, who was the director at the time of IPS, she's testified that there were not rumors, I can't remember the exact word, but speculations. Speculations about.
I use that term all the time, right? Oh, we were having speculations about someone's email usage.
Yes, I believe that was the term that she
Yes.
used
Yes.
about her email use.
And of course,
And
that's a
this is in
disingenuous way of
2000.
putting it, isn't it?
Correct. And I mean, because at
They
that
all
point,
do.
if they're, the follow-up question to that is, well, what did the State Department do? What did you do as a result to determine whether these speculations are true or not?
Well, and if you want to know why the court in our case is mad, we had indications all that was going on. We didn't have the detail, but we knew they were playing a game, and the court recognized they were playing a game. And the frustrating thing from my end is that you had the State Department and Justice Department playing a game under Obama, and up until, and still to this day, the Justice Department and State Department have defended this misconduct. And Judge Lambert attacked the Justice Department and State Department for still prevaricating with him.
Right.
Not under Obama, but during this administration. So President Trump, in my view, needs to start asking why they're still defending Hillary and the State Department misconduct here. But we're still got to get more on this Hackett testimony.
Right.
Because then it comes out that all the emails get shipped back to the State Department, and Hackett's asking more impertinent questions.
Right, right. And one of them being because they have 12 banker boxes of emails that are returned, and then they find out, and by they, John Hackett and others at State Department, that 30,000 were deleted and were
Right.
not returned and deemed personal. So Mr. Hackett, as the director of IPS, obviously one of the important, what was the protocol? What were the guidelines? What were the parameters that Secretary Clinton's team used to determine that 30,000 emails, because that's not 3 emails, it's 30,000, that's a significant amount, that they were not official federal records. And he raised that with with Patrick Kennedy, who was then the Undersecretary for Management. And according to Mr. Hackett testified that Mr. Kennedy would make that request of Secretary Clinton's team. However, by the time Mr. Hackett had left the State Department, Secretary Clinton's team had never provided that information.
This extraordinary testimony we received from a former State Department official. He's the former director of the Office of Information Programs and Services, which essentially is the Freedom of Information Act office, involved with obviously responding to FOIA requests, handling records generally for the State Department. And a gentleman's name is John Hackett. He's no longer there, and you'll see why in a moment. But he testified that he had raised concerns about Hillary Clinton's emails use repeatedly. Specifically, he raised also concerns about how her lawyers were going to review all those emails that she took, ignored, and plus he raised concerns that they were interfering improperly with email productions to the Congress and to the public related to Benghazi, interfering in a way that placed our national security at risk. So when I say blockbuster, I mean it. So Hackett was a part of court-ordered depositions and testimony that we were granted by Judge Royce Lamberth, who, as part of a Benghazi FOIA lawsuit we pursued, was quite upset that the government tried, the State Department and Justice Department, tried to hoodwink the court and shut our case down before they fessed up to having Clinton emails that they were trying to hide from us. And so he granted us discovery. We deposed our attorneys we're essentially completed that first initial round of discovery. Our attorneys have questioned about a dozen witnesses in the last few months. We've gotten new documents and other things. And some of the highlights of the testimony we've received thus far, both written and in person. Remember, Hillary Clinton's lawyer testified she got immunity after she deleted the 33,000 emails. The top FBI official who was supposedly investigating the Clinton email issue, admitted that they found Clinton emails in the Obama White House, the executive office of the president. The top security official at the State Department, deposed by us, he admitted they warned Hillary Clinton not once but twice about her email practices, or specifically about don't use a BlackBerry and be careful about the use of personal emails for government business. She was warned. And then we found out additional documents showing that the Obama White House was involved in the cover-up and lies about the Clinton email system. I mean, one of the big issues is that, well, no one figured it out until late in the game that Hillary Clinton had this email system. That's not true. Well, go back and think about it like this. Hillary Clinton is the head of the State Department. She knows about her system. Her people know about her system then. The State Department knew from the beginning. And certainly they knew generally as a matter of under the law related to the Federal Records Act and the Freedom of Information Act for years. But then they couldn't avoid the issue because people started asking specific questions on her emails, and that's when they started lying to the American people about it and misled the courts and Judicial Watch. And that's why there's this email scandal, because not only was there the mishandling of classified information, but you also had the misleading of federal courts, Congress, subpoenas, things like that, that were all of which were impacted negatively by the big lies about the Clinton email system. So the judge wants to know, was there an effort to hoodwink him? There's no doubt there was. He also wants to know whether Hillary Clinton used her system to avoid the Freedom of Information Act. No doubt that happened. And then more as importantly, because it's FOIA, well, where are the other emails that may be out there that Judicial Watch and the American people have a right to have reviewed and released to them? specifically Clinton emails. And this is all in the context of a lawsuit about Benghazi. And so the judge wants to know, was Benghazi one of the reasons all of this scamming took place? They didn't want us to know about the emails because they were afraid what might be in there about Benghazi? Well, you'll see that may be the case here. So getting back to John Hackett, he's this former top official in the State Department involved in records management. And he was blowing the whistle repeatedly on what Hillary Clinton was doing. In June of 2013, there was this famous photo, you may have seen it, Hillary Clinton's wearing a dark pair of sunglasses looking at her BlackBerry. And I think she used it for her first Twitter picture or something like that, or associate with her Twitter feed when she opened it. And this is what we say. Hackett testified about his initial concern over Clinton's email use arose in June of 2013. Now remember, we weren't told about her email use publicly until March of 2015, almost 2 years later. He saw that photograph and he thought, and this is a quote, and that got me thinking, well, what was that BlackBerry? Because the picture was of her on a government plane. Was it a government BlackBerry? And if so, were there emails relating to that BlackBerry? Oh boy, that's an inconvenient question. And he went and talked to his director, Cheryl Walter. And she said after seeing that photograph and suggested we had to be careful about what sort of responses we made related to Hillary Clinton's emails. If there was a no records response, that was being given out. So they were giving no records response, lying when people were asking about Clinton emails. And he said, well, we have to stop saying that. And so you know what they did? They essentially just stopped answering the requests, wouldn't tell them anything one way or another. So they specifically and actively hid her email usage from those seeking these records as they're able to under law, including Judicial Watch. You know, and he looked up and he pursued it further. He said the other thing that we did, or I did at the time, was we wanted to find out what this BlackBerry meant. So we tasked, my recollection is, we verbally tasked the department's records manager at the time to look into the BlackBerry. And they asked Clarence Finney, who was the secretary's manager of records in her specific executive office, to ask him what he knew about the emailing habits. And she didn't find out much from him. And she asked the State Department, that's part of the intelligence community, and they asked to see if there were any classified emails on the classified systems that the secretary might have produced. And they said they didn't have any. So there was a lot of confusion about exactly what that BlackBerry meant at the time. You had a concern as to how the department was responding to FOIA requests that related to Secretary Clinton's emails after you saw the photograph holding a BlackBerry. My recollection is, and I had been there 2 months, that someone had told me that, and I can't remember, that she did not have an email account, a government email account. So there was obviously a contradiction here when you know there's that photographs. So we're just there trying to find out what was the ground truth. So that's why I had a concern about issuing responses that said no records had been located. You know where the records were? Well, I guarantee you some of them were in the State Department because she was sending emails in the State Department. She had taken them improperly when she left office. So what's even worse is, he wasn't asking a question they didn't already know an answer to. He was being gamed, it looks like to me, by his colleagues in the supervisory staff at the State Department. Why? Because the State Department at that time had already been lying. They had said there was a no records response despite knowing that there was this Clinton email issue out there. And that no records response, that lie, was set up in consultation with where? The Obama White House counsel's office. So Judicial Watch's other discovery found that the Obama White House counsel's office was orchestrating the no records response on the Clinton email issue. So, you know, when you wonder why Hillary Clinton hasn't been prosecuted yet, you know, one of the answers is because you can't prosecute her without raising issues about the conduct of other people in the Obama administration, including in the Obama White House. So Mr. Hackett had this inkling something was up, right? And so fast forward, Judicial Watch's FOIA in this case, and another case about her conflicts of interest, kind of forced the State Department's hand. They know there are these records out there. The FOIA requesters, like Judicial Watch, aren't going to take, are going to figure out something's up. They had given something to the Benghazi Committee, which was formed thanks to Judicial Watch disclosures, suggesting there were Clinton emails, and they knew they were going to have to confront that as well. But it was in our case, in this case specifically, that they first admitted that there were other records they need to search. They didn't tell the court honestly what those records were, which were all the Clinton emails. So Hackett knew about these other emails. So she had taken 60+ thousand emails and only had returned 30,000. And Hackett was concerned, well, why are we relying on Hillary Clinton's people to tell us what government records are? She had no right to take those business records with her, but she did it anyway. And she said, well, I'm going to tell you what you're going to get back. And this is what Hackett knew something was up in that regard. And he talked to the State Department about this. I recall it wasn't much of a conversation. I mean, we have to say it was emphatic to the Undersecretary of Management, who was Patrick Kennedy, really top official there. And I didn't speak in tones like that very often to him. So he was pretty aggressive. You know, that we needed these guidelines, meaning that when you look at a government record or a document, you got to know what the rules are in deciding whether they're government or personal. And of course, you don't outsource it to a Clinton lawyer to do it. And when you said the Undersecretary, we're referring to Patrick Kennedy, he says yes. So our attorney asked, and then he goes, I think there might have been raised it with two other people, Rich Visick, another senior official acting office of legal advisor, a lawyer, and Peggy or Margaret Grayfeld, who was an executive level State Department FOIA officer. She's since passed away. She's been the FOIA person from our, we always recognize her name because she was always responding to Judicial Watch FOIAs. And our lawyer asked, why did you feel so strongly that this was necessary that they provide the information? Well, we heard there were 50 or 60,000 emails, and they being the Secretary's team, had culled out 30,000 of these, so we wanted to know what criteria they used. The standard for the National Archives is very strict. The National Archives sets records policies for the government agencies. If there were mixed records, that would be considered a federal record. If there was mixed personal and mentioned a discussion, there would be, under the narrow National Archives rules, it would be considered a federal record. And do you know if the emails that were returned by Secretary Clinton and her attorneys, that they followed the guideline to include an email that would include mixed information, personal or official? I don't know. Was a request ever made by Patrick Kennedy or anybody else who you raised this to? Ambassador Kennedy told me he would ask for the guidelines. Do you know if the guidelines were ever provided to Patrick Kennedy? Hackett, not during my tenure at the State Department. Well, let me break that down for you. Because Hackett, it's even worse than what Hackett suggests. The irony is, when Hillary Clinton was Secretary of State, as she's writing emails, under the rules and regulations at the time, she could decide which is government, which is personal, and she could have just deleted personal emails as she was writing them, or on a regular basis. There's nothing that prevented her from doing that. But once she left office, all of those records became government records immediately. So she shouldn't have been able to take any of them without a review, in the least. Now, she might have gotten copies of some of them. She certainly wouldn't have been able to take classified information, which she improperly did, which is just an outrageous violation of the law. But even her personal emails, the government would have kept. Because, once you're gone, they're theirs. It does not mean that Judicial Watch or anyone else would get, quote, personal information under FOIA. Heck, we don't want personal information under FOIA. We are asking for government records. So if she's setting up yoga classes or wedding planning, you know, the big lies she was telling about what was in the emails that she deleted, we wouldn't be getting those under FOIA. And that's not the issue. The issue is she took emails that she wasn't able to take, and then when the government wanted them back, because their hand was forced by Judicial Watch, she and her lawyers decided what was going to be government and what wasn't. And sure enough, because Judicial Watch did receive the records that were deleted, at least some of them, there was classified information and government records among the records that were deleted or otherwise hidden. And if they had listened to John Hackett, if they had followed the rules from the beginning, not one of those records would have been deleted. Because, you know, depending on which report you read, I don't know what the FBI suggests, told one news outlet that they got 17,000 records recovered. I don't think that's true. Based on our analysis, the FBI was only able to recover 5,000 of the 33,000 emails that Hillary Clinton and her lawyers deleted. And we know among those records that were those personal emails that were deleted were plenty of government records, because we got them. We wouldn't get them if they weren't government records, and classified information. And if people like Hackett had been listened to, if the rules had been followed, if they had followed the law the way they were supposed to, none of that would have been deleted. None of that obstruction would have taken place. And they allowed it to happen. That's why I say testimony like this ought to blow it wide open. Because they all knew at the State Department what was going on. They were warned, they knew directly, and to the degree they say, I didn't know, they don't have any plausible deniability, because you had people like John Hackett, this eyewitness, come in and tell us he told people and warned them about it. Isn't all that outrageous? But it gets worse. There have been rumors that, and I talked about this, and I hope you're able to review a discussion I had with one of our lead attorneys on the case, Senior Judicial Watch attorney, Ramona Kotka. And and it's hard. We're a transparency organization at Judicial Watch, and so we get documents. We like to get documents. We like to get more information rather than less. We're happy when the government errs on the side of disclosure and gives us more documents. Having reviewed hundreds of thousands of documents in my 21 years here at Judicial Watch, this is my 21st anniversary at Judicial Watch, believe it or not. So I've looked at a lot of documents. My colleagues have looked at a lot of documents. I have a pretty good feel about what documents, what typically is withheld under classified information, what is classified, what isn't classified, what you ordinarily get, what you don't ordinarily get. And reviewing many of the Clinton emails, what struck me is that there was material in there that could have been classified. Like I said, there are probably few people in Washington, D.C., a few organizations, in the least in Washington, D.C., who's had as much experience reviewing government records under the Freedom of Information Act as Judicial Watch has. Dare I say it, no one else has, given the sheer volume and the millions of records we've received. And I remember thinking, well, I'm not going to complain, we're getting these records. I'm not in a position as a layperson to say that needs to be classified, but my thinking was that they were releasing material that otherwise should have been classified because they were trying to protect both themselves and Hillary Clinton from any additional criminal liability. The more classified information, the worse it looks from a prosecutorial perspective for Hillary Clinton. So like I said, I have suspicions, but I always have lots of suspicions, but I don't necessarily have evidence to back up these suspicions, in this case, other than my own experience, however extensive. Well, John Hackett confirmed my suspicions. And this is how he did it, because he testified that he was concerned about interference in the document release process, the FOIA process, especially as it relates to Benghazi. And he testified that they were, let me get to the section of the document about this, forgive me here. Judicial Watch asked Hackett, he believed that there was interference with the formal FOIA review process in 2014, because that was when they were getting Hillary's emails. Hackett said he believed that some bureaus were convinced, and analysts were convinced, once it was explained to them to redact something but use a B5 exemption versus a B1 exemption. What does that mean? B5 is a non-classified exemption that allows the government to withhold what is called deliberative process material, basically the back and forth before a final decision. It's material we're often very interested in, we often don't get. And it's a big loophole that prevents the government from giving us a lot of documents. B1 is the national security exemption. So when you're classifying something or withholding something under B5, you're saying that underneath it, underneath the black marks that you often see with redactions, there's nothing classified. But when it's B1, they're telling you underneath those black marks, it's classified. And what Hackett is saying is that they were underclassifying and mislabeling classified material as unclassified in producing these records to the American people and to Congress. And he also testified that the lawyer involved in this case, Catherine Duval, who, by the way, comes from Lois Lerner land at the IRS before she went to the State Department, that she wasn't doing the proper consultations with other government agencies, you betcha, about classified information. So it was a double whammy. They didn't want other agencies to get involved and start classifying stuff in a way to make Hillary Clinton look bad. And then when they had the decision power making power themselves, you had State Department officials underclassifying and interfering with the process. And so when you underclassify material, it means you're telling people it's not classified and you don't need to treat it as classified, which means it's not protected from disclosure the way it's supposed to be. It's not put on a secure system in the State Department. The Congress doesn't treat it as classified. National security was put at risk as a result of this cover-up activity to protect Hillary Clinton. That's what this testimony shows. Attorney General Barr and the Justice Department have more than enough evidence, uncovered by Judicial Watch, of course, to reopen the Clinton email investigation, to not only investigate Hillary Clinton, but her former colleagues at the State Department, frankly, in the Obama White House, and in the Justice Department itself. They were all in on this. They were all in on it. So one of the reasons, as I say, the Justice Department isn't trusted is because of the corruption involved in the protecting and the targeting of Donald Trump. And I talked to you last week about these astonishing records, these declassified materials we received from the FBI, documenting FBI interviews with Justice Department official Bruce Orr, who told the FBI that the Clinton Fusion GPS spy, Christopher Steele, was desperate to stop Trump. They show that Orr was working with his wife Nellie, who worked with Christopher Steele and the Clinton Fusion GPS gang, to launder information into the Justice Department and into the FBI. In fact, he was giving them materials. And all sorts of other astonishing information, such as the FBI had it in for President Trump and was trying to investigate him through this improper process of using Bruce Orr as a cutout to talk to the Clinton camp, Fusion GPS. This is after he was elected and after he was president. Incredible documents, uncovered by the media, by the way. Other than our friends at Fox News and some independent media online, none of the big media have covered the extraordinary disclosures in this historic release of FBI materials about the Donald Trump investigation. I thought they were interested in the Donald Trump investigation. Oh, no, they're not. They're only interested in anything that makes Donald Trump look bad because they're part of the coup cabal. If there are documents coming out showing FBI or DOJ corruption, the media ain't interested in it. And that's why you always have to turn to Judicial Watch to get the truth about what's going on, about the greatest corruption scandal in American history, which is the taking over of the government agencies, intelligence, state, defense, by the political operation of the Obama White House and the Clinton campaign to target President Trump and to protect Hillary Clinton. So we get this historic release of information last week. And then we get another batch of documents this week. And it was a separate lawsuit that we had filed showing that we had asked for documents separately, asking for communications with Fusion GPS and Nellie Orr and things like that. So we had to sue separately for that, in addition to the lawsuit we had for the FBI 302 reports that were released to us last week. And we've been getting documents there showing that Nellie Orr had it in with the Justice Department. But this is the big batch. This is 300 pages, well over 300 pages, 330 pages, showing what exactly Bruce Orr took from Nellie and gave to the Justice Department and the FBI. And it's incredible material. They show that Nellie Orr was sending material from Fusion GPS to her husband, because the FBI notes detail that the transfer took place, and she was coming up with some crazy garbage about Donald Trump. There's a report called Who, September 2016. So this is, I'm going to find it here, forgive me. I do prepare for these presentations I give to you, but there's a lot of material we're dealing with here. So unlike the folks you see pretend to give you news on TV, I'm trying to figure out what the truth is before I go on here. And this is the document that Nellie Orr provided to her husband because of Fusion GPS and Clinton. So this is a Clinton document. And remember, in the 302s, Bruce Orr said that he gave the material, the FBI acknowledged they got the material from Nellie Orr with the Fusion GPS material struck through. So they were trying to disguise the origin of the material. And these documents show that Nellie Orr was sending Bruce Orr all this dossier garbage. There's even reference in text messages to the P dossier or the yellow dossier, which is that outrageous defamatory smear tying President Trump to some weird activities in Russia. And here she comes up with this chart. There's about 80 names of Russians and others that she tries to Trump world. And it didn't matter. It was, as I say, an insane version of 6 Degrees of Kevin Bacon. I don't know if you've ever heard of that, but I may be dating myself. Am I dating myself, guys? No, my colleagues are saying no. So the line is, take Kevin Bacon, and you can take anyone in the country, and they'll be 6 degrees away from Kevin Bacon. You can tie him to Kevin Bacon. Well, imagine doing that for a figure like Donald Trump. That's what was this dossier, except it's the Russified version of it. And the document shows the list of individuals allegedly linked to Trump and Trump world generally include a Russian involved in a gangland killing, a Uzbek mafia don, a former KGB officer suspected in the murder of a Westerner, a Russian who reportedly buys up banks and pumps them dry, a Russian money launderer for Sergei Magnitsky, a Turk accused of shipping oil for ISIS, a couple who lent their name to the Trump Institute promoting its, quote, get-rich-quick schemes, and this is my favorite. She also tries to figure out who was the guy who allegedly poured Trump a drink in Moscow. That's how crazy this is. So you've got this chart given to the FBI through her husband, Bruce Orr, created with Clinton DNC campaign funds, that is just 10 pages, 80 names of a crazy conspiracy theory. I tell you what, if you walked into a room and you saw all this type of material on the wall with all the strings connecting everyone to Trump, you'd say, who's the crazy person who came up with this? Yet this was the basis for the FBI spying on President Trump. Nellie Ohr, whose husband worked at the Justice Department, was hired by Fusion GPS. It's now apparent why they hired her. It was like hiring the Justice Department. Think about this. You're at work and your spouse is sending you material at work all the time and you're telling your colleagues to use it? Why would you think that's appropriate? Certainly as a Justice Department official. The documents also show she sent around a Manafort chronology. I didn't know that Nellie Ohr was involved in helping the FBI with the Manafort investigation. Did you? I wonder if Paul Manafort knows that. Also, Bruce Ohr helps connect some of his colleagues doing another criminal investigation with his wife. By the way, that whole situation is the subject of a criminal investigation, or at least ought to be, because Nellie Ohr said, I wasn't doing anything for the Justice Department. She may as well have had a desk at the Justice Department. Hillary Clinton may as well have had a desk at the Justice Department because Nellie Ohr was doing her bidding. Creating this garbage dossier, sending it to her husband, who's voluntarily printing it out, or handling, according to the 302 reports, handing it to the FBI. What's going on here, folks? I'll tell you what's going on here. By the way, none of this stuff is credible. It's obvious on its face it's not credible. As I told you, read the dossier, you'll see it's ridiculous. And of course, it wasn't panning out. In January 2017, Comey admitted this is the day he ambushed President Trump, President-elect Trump with it, after meeting with Obama and Biden in the Oval Office, by the way. He admitted it was salacious and unverified. Mueller in his report admits the dossier is unverified. It wasn't panning out, yet they were telling a FISA court repeatedly it was good stuff, and they knew it wasn't. They knew their agent, their Christopher Steele informant, was compromised. They knew it was politicized because they were desperate to stop Trump. Both Fusion GPS, obviously, and Peter Strzok with his insurance policy. What was going on? They were desperate to stop Trump. So what were they doing? They were vacuuming up anything to backfill the file with materials that said Trump and Russia in the same document. It didn't matter whether it was valid. It didn't matter whether it had checked out. They just wanted it in the file, so they had justification to target the president with an unprecedented spy operation, force a special counsel to try to remove him from office and put him in jail. That's what was going on. And we proved it. And this is why the media doesn't want to talk about it, because we proved it. This is the dirty laundry of the coup cabal. It's been gotten by Judicial Watch as a result of FOIA litigation. But it's not over, because we get this one batch of documents. I tell you, we get the material. It's 300 pages. We got to look at it carefully. And then we get more material Nellie Ohr is sending. She isn't even just limiting her contacts to her husband. She's talking to his staff. Bruce Ohr was running essentially the international crime section of the Justice Department. And Nellie Ohr is sending email after email after email anti-Trump material as well to his staffer, who is a Russia expert as well. And the emails, it's Russia language news reports. I haven't translated them. Why is that, on what earth is that appropriate? So we know Christopher Steele was an informant for the FBI, right? Who worked for Hillary Clinton. Nellie Ohr was an informant for the Justice Department through her husband. It was a partnership. So I don't know if the Justice Department's looking into this outrage. Presumably they are. People often say, well, does the Justice Department know about this? These are Justice Department documents. They've been hiding them from us. The FBI 302 reports have been hidden from us. This is an unprecedented attack on the president. And when you see these documents, Bruce Ohr conspiring with the FBI to launder this garbage from his political agent wife and the foreign spy Chris Steele, it was an international coup effort. It was sedition. And the fact that a grand jury hasn't hauled all these people in a public way to question them under oath is a miscarriage of justice. And do you think the IG is going to make the conclusions I'm drawing for you here? No way, Jose. It's not going to happen. But you can trust Judicial Watch to keep on getting the goods here. Where's Congress on this? Nowhere to be found. Absolutely nowhere to be found. I mean, I'm happy to do the work. My colleagues are happy and honored to be able to do this work at Judicial Watch, but isn't it outrageous? Isn't it outrageous that Judicial Watch has to do all the heavy lifting? And we have to fight tooth and nail the Justice Department to get the information out? About, as I said, the worst corruption scandal of all time. And we wouldn't, virtually every important thing we know about it is because of Judicial Watch's pressure. I want you to go to our website, go to our YouTube channel, go to our Twitter channel, go to our Instagram account, and if you're not following us, you should be. And even if you don't want to follow us, you should. Let's say you're not on Instagram. Go on Instagram, create an account, start following us. Get the word out. I'm asking you to be active on social media, which is a key area to getting the word out and educating your fellow Americans, your friends, your colleagues. And the only way you can do that is by participating. And I know the social media giants, they don't like conservatives, but we can't be run out of town and we can't be run out of Dodge. So I want you to support Judicial Watch by being active online and spreading the word about our good work and our educational activities about what the government's up to.